Hey friends, attorney Kyle Newman here with the best tips and insights for injured New Yorkers. And in this video, we're going to discuss how to prove a slip and fall in New York. And if you were involved in a slip and fall, make sure to stick around till the end when I'll give you my best recommendations on what to do if you were involved in a slip and fall and you were injured. But before we get started, make sure to smash that subscribe button and hit the bell to get notified of our next video. Your support for the channel is amazing and it really helps us grow. Also, if you have any questions, just leave them in the comments or reach out to us directly and I'll get right back to you. All right, so slip and falls are a type of personal injury case where a person was injured as a result of some defect on the ground that either blocked or obstructed their normal walking motion and in turn caused them to fall and be injured. Some of the most common types of trip and falls happen when there is a cracked or uneven sidewalk, a slippery foreign substance on the ground, or when there's been some type of construction in the area that left the ground dangerous in some way. When injured in a slip and fall, you can bring a lawsuit, but you'll have to prove two things. The first is liability, which is done by proving that the person or business responsible for the area in which you fell either caused the condition or had notice of it, but failed to fix it prior to your accident. And second, you have to prove the nature and extent of the injuries that you suffered. In proving liability, or who is responsible for the accident, there's essentially three ways to hold someone accountable for a slip and fall injury. The first is by showing that the responsible party caused and created the dangerous condition that led to your injury. This happens when a party leaves something on the ground that shouldn't have been there or repairs a surface in a negligent way that leaves that walking area more dangerous than it should reasonably have been. And in these types of slip and falls where a party caused the walking surface to become dangerous, there may be a failure to warn component where, let's say, a building owner, they had someone mop the floor and didn't put out a caution sign. Or let's say Con Edison was repairing something on the street, ripped up an area in order to perform repairs, but didn't rope it off or put caution tape, and someone tripped and fell over that ripped up area. In order to prove that the property owner or outside entity is responsible, you first have to show that they did in fact cause and create that condition. And this is done through a process called discovery, where during the course of a case, we collect evidence from the party that we're suing. Things like work records, maintenance records, and perhaps surveillance footage to see who was performing the work in the area that led to the accident and whether they're responsible. The next most common way to prove liability in a slip and fall is through notice. And this is done by showing that a responsible party either knew or should have known of the dangerous condition, but failed to take reasonable steps to prevent it, which basically means that they should have fixed it prior to the accident happening. So there's two types of notice. There's actual notice and constructive notice. And in order to prove actual notice, you have to show that the property owner was actually made aware of the dangerous condition within a sufficient time to fix the defect, but didn't do so, and that caused the accident. And this is typically done through showing things like prior written complaints or violations, or getting records through 311 or police to show that they had notice of the condition. Constructive notice, on the other hand, is shown when a property owner does not have actual notice, but they should have known about the condition but failed to do so in a reasonable amount of time in which any responsible party in their situation would have done so. The catch with constructive notice is that it does not apply to municipal slip and falls against, say, the city or state of New York or the MTA. And in that case, when you're suing the city, you can only prove a slip and fall case by showing there was actual notice in the form of prior written complaints. Look, it sucks, but as you'll learn, the city and state gets a huge break when it comes to accidents that normal people and businesses just don't. For instance, when suing a person or business, a slip and fall victim will typically have 3 years from the date of the accident to bring a lawsuit. But with the city or the state of New York or any other municipal entity like the sanitation department, police, or MTA, you have to file what's called a notice of claim, which is essentially a 2-page document within 90 days from the date of the accident. And then you only have 1 year and 90 days to file the lawsuit, which is far less time than the 3 years against everyone else. One last thing about liability before I move on to the second part of these cases is that you as a plaintiff, the person who is injured, you can also be blamed either wholly or partially for causing the accident, because legally you have a duty when you're walking or traveling on a street or surface to see what there is to be seen. So if a person is goofing around, they're rushing, they're not using proper footwear, or are negligent in some other way, the defendants in these cases can actually come to court and ask the jury to apportion a percentage of the blame against the injured person. All right, so let's say you're able to prove that a person or entity either caused your accident or had notice of that condition and didn't fix it in time, whether it was actual or constructive notice. Then we still have a job to do, and that is called damages, where we have to go to court and prove the severity of your injuries by establishing things like the cost of medical treatment, lost earnings, and pain and suffering, both in the past and the future, to a point that the person is expected to live. And when you talk about trip and falls, people have the tendency to dismiss them. Like, this can't be that bad. I've slipped and fell 1,000,000 times and I never got hurt. And while that may be true, slip and falls can lead to some of the most devastating, permanent, and truly life-changing injuries imaginable, and here's why. When a slip and fall occurs, a person's typically walking in their normal fashion. They're looking ahead, they're going about their business, and they're really completely ignorant to a potential hazard waiting right in front of them. And when you're walking normally and something suddenly causes you to trip, say a raised sidewalk that catches your toe, this causes an immediate reaction where the entire weight of your body will violently and unnaturally move in the direction of the defect that you never saw coming. And since you weren't expecting this to happen, you weren't going to be prepared for it, like say you would be if you lost your balance or missed a step, giving you time to at least brace yourself for the fall. But in trip and falls, these things happen so suddenly and your body moves so forcefully that many people don't have time to brace themselves and they won't be able to shield themselves from the fall. And let's say you rolled your ankle because of a defect, that is going to happen so fast that you're not going to have time to prevent it no matter how agile you are. And this is why slip and fall injuries are so bad. When you fall forward violently, you're likely to strike your head, your face, your nose, and when you slam on that hard pavement with the entire weight of your body behind you, whatever part of your body that unnaturally breaks that fall is the one that can be severely injured. And I've seen it time and time again. Broken bones, traumatic brain injuries, facial fractures, hip fractures, the list really goes on. And when you break down the mechanics of these accidents, you can see exactly why. So after a slip and fall happens, there are a few important things to do to preserve evidence of the accident and to establish a strong foundation for your injuries. The first is to call 911 and speak to the building owner or the supervisor directly. Document what it was that injured you by taking pictures and video on your phone. Also, you want to look around for witnesses, and if they were there, get their phone number and email. And never ever admit to any wrongdoing to anyone at the scene. And if you were injured, no matter what, if it was slight or major, wait for an ambulance, go to the hospital, and follow up with your doctors so your injuries are well documented. And don't try to be a hero. If you're hurt, stay out of work. And make sure to follow the instructions of your doctors, despite how time-consuming or annoying it might be. Because property owners and municipal entities will typically have large insurance policies of at least $1 million and up, they have a lot to lose. And with this much money on the line, these insurance companies and the defense firms they hire will do everything they can to discredit you, to blame you, and minimize your injuries. That's why it's so important to hire an experienced personal injury attorney right away to help guide you through this difficult difficult process of proving a slip and fall case. And look, if you need help or if you have questions, just give me a call. My office, we've only been doing this for about 40 years. All right, if you made it this far, thanks so much for watching. Like, comment, and subscribe to our channel, and I'll catch you on the next time.